idiot.
Yeah. And to know that the standards were so much higher for the Supreme Court, conduct and morals than it is now, that's astounding to me, because I had thought they were the high of the high, you know. What did you think about some of the video?
Which video?
The one about judicial myths?
I don't know.
Joy?
I don't know.
Did you disagree?
I agree with some of the stuff, I guess.
The what?
I agree with some of the stuff.
Okay, that's fine. Was there anything blatant that y'all disagreed with?
I don't really think so. A lot of it seemed like really accurate, because from what you said, they have the writings and everything. I guess that's where they originate from.
Was there something specifically that you disagreed with? Was there anything new that you learned from it? No? Okay. Okay. Have you all finished up watching all, Injustice? Injustice for All?
But yeah. Not yet, no. I tried to watch it and I got stopped because I had to do all the work around my house.
Okay.
I think it's pretty funny. This is kind of funny to choose it.
Wait until you see the second half.
Oh no.
Please watch that movie Friday. It is posted now, it is available, and, I didn't go through any of the, online services. I got it fixed up myself this time, so it should roll without any problems.
I have a quick question.
Yes.
It's kind of off subject, but I was taking the exam, and one of the questions, it was saying that the lady, she got 6 months up into, 6 months in the county jail, and I put that it was a misdemeanor, and it was wrong, but the answer was a felony. Could you explain why?
Okay,
Was that the amendment test?
No, it was the unit one, because I thought a felon was more than 1 year in,
a felony is usually greater than 1 year in the county jail and $1,000 or more. And so if that question said that she stole like $500 and got a year in the county jail, that would have been a misdemeanor.
Okay.
But if she stole $1,000 worth of material, then that would automatically make it a felony. And
I thought it was just either year-based or.
do what?
I thought it was like year-based, or if it's like the crime is like more than $1,000. I thought it was like either or.
You say a year based?
Either the sentence is a year long, or it's, the.
I'm not sure, I think they can do both.
Does it require both, or?
No. The judge has a lot of leeway on how he can sentence. I mean, he can sentence people to, I'm trying to think. Let's say that the guy keyed a car, all right, and they knocked it down to a misdemeanor. Well, the judge could have him washing and waxing all the police cars for 6 months. He can be very creative, and he has a lot of leeway in the way he can sentence. But generally, in my understanding, if a crime involves a monetary value greater than $1,000, then it's going to be a felony.
Okay.
A felony usually results in jail. Well, when I say jail, in prison, not county jail, but in prison for greater than a year, and the fine has to be greater, I think, than, well, I would say more than $1,000, but I'm not sure. All right, well, we're moving on to talking about the court system, And the United States has what's called a dual court system. We have the federal level and we have the state level. Now, our system in America is an adversarial system. And I'll tell you about that in a minute. Other systems around the world has what's called an inquisitorial process. Inquisitorial. Now, a jurisdiction is the range of the authority of the court. Okay? We use that word also with police. You know, the jurisdiction of the municipal police department is within the city limits. With the court, with the county, it's within the county, and the state can go anywhere. The functions of the court is to enforce now this is where we're at right now. The functions of the court is to enforce the norm and to try and intervene in disputes, and then policy making. Now, I beg this book to please show me in the Constitution where it says the courts are supposed to make policy.
So the legislation, right?
That's the legislators. That's the legislator's duty. And when we, as instructors, take this and just follow this and tell you, yeah, we're supposed to let the courts make policy, that's erroneous. That's erroneous. They are not supposed to make policy. They are only supposed to interpret the Constitution. Now, I talked about the adversarial process a minute ago. In our system, and our system is based on the British system. In our system, we have the adversarial process, and in doing that, within the courtroom, the evidence is examined. But you have two sides. We call them the defense and the prosecution. Now, the prosecution takes the side that says, okay, we're going to prove this guy did it. And the defense takes the position, we're going to show you this guy is innocent. Now, because of due process, the assumption should be this guy is innocent until the prosecution has done their job. And it's the burden of proof is on the prosecution. Do y'all remember where I said there's an exception to that? There is an exception. It's in the military.
Oh, that's right.
And in a court martial, they're assumed to be guilty until proven innocent.
Why is that?
I don't know. But you know, I think it's kind of interesting that when you join the military, a lot of your rights are given up.
Mm-hmm.
There are many, many of your personal rights that are given up, and that's one of them. Each side is represented in an adversarial process. Now, each side is allowed to challenge the other side. They are allowed to say, no, this evidence is no good, or this evidence was obtained illegally. And so they have, you know, each side has the right to present evidence and to challenge evidence. The goal of the adversarial process is to convince the judge and jury. Now, the inquisitional process, here the judge takes the active role. He will question the witnesses. he will examine the evidence. And he or she asserts themselves into the investigation. Now, there is a lot of countries around the world that use this. Now, all I can tell you is, when I went to Mexico many years ago, I was with a missionary family, and we were riding along, and a bus, let's see, there was something happened. I can't remember.
Car wreck?
I'm thinking it was a car wreck, and somebody was very seriously hurt, and everybody in the bus just went, and everybody ran away. And I said, "What's going on?" And he said, "We're under Napoleonic law." And he said, "Whoever the police can catch gets the charge." He says, and so that's why everybody's running, because nobody wants to take the blame. Now, how would you like to have that kind of a system?
Do they not do an investigation or anything? No.
It's so corrupt, it's basically how much you can pay.
Oh,
How much you can pay to get off, and like if they arrest you, and I suppose if you got a pretty good amount of money right then and you can pay them off, then they'll find somebody else. But, we talk about our system, and our system's not perfect. But until you show me something better, I think we've got the best going. And it can be improved, but it's not as bad as Napoleonic law. It's not anarchy, and so I submit for your consideration that it may not be perfect, but it beats anything in second place right now. The function and structure of American courts. Well, the structure is federal and state. Federal and state court systems have a trial and appellate court. Now, it's set up where you have trial courts of limited jurisdiction. These are the courts that will try misdemeanors and small claims and small amounts of money. Trial courts of general jurisdiction, appellate courts, problem-solving courts. Each state has a Supreme Court that is the last resort for cases involving state law. The Supreme Court is the highest court in the land and rules on matters involving the U.S. Constitution. The SCOTUS, Supreme Court of the United States, oversees state and federal courts by interpreting the United States Constitution. This is what the real battleground right now for this confirmation is, because the nominee has a judicial record of interpreting the Constitution, and if she gets on the bench is going to take a significant turn of going back to interpreting the Constitution instead of using it as a legislative tool. And that's why there's people that's just running around with their hair on fire, because they just can't stand that thought. They, think about this. Do they ask, significant legal questions, or do they ask questions like, well, if you get on the bench, are you going to rule against Roe versus Wade? That's not a significant question, And so, they will, if they have any integrity, they will say, I'm not going to discuss cases that are already coming before the court. And there are several cases that are coming up like that. The SCOTUS is supposed to protect the rights. They're supposed to protect the Constitution. They're supposed to interpret the Constitution. The state courts, well, you have your trial courts, and then it goes up to, if you want to appeal the ruling, you can go to the state Supreme Court and then the appellate court, state Supreme Court, and then you can go to the SCOTUS. The state appellate courts, they're usually called the state Supreme Court or appellate courts, or like New York, the New York Court of Appeals. There's several names for the same type of court. There is a third type of court, and that's called the tribal court. It's interesting, a lot of people don't know about this third court. The Native Americans have the privilege of being able to have jurisdiction over their own land and have their own court, tribal court, for being able to take care of those legal matters. And it's honored, their decisions are honored. Federal courts are supposed to have a limited range of criminal cases, okay? They will deal with people only who violate criminal laws of the national government. You don't have an FBI agent running around and arresting somebody for a state violation. They are only concerned with national laws, with federal laws, okay? These are laws like counterfeiting, smuggling, kidnapping, trafficking. The ratio, for every one federal case, there will be 10 state offenders in prison. Now, there is a problem now because they're looking at, okay, terrorism. Is that going to be a local or state problem, or is it going to be a national problem? Because when you're talking about domestic terrorists, they can have cells in different states and stay within that state. But then we're talking about, you know, what are they planning on doing? I can't tell you how many times I've done that. One of these days it's gonna take the last hit. What is it that they're doing? How involved is it? What kind of weapons are they using? And so this is going to be a problem on determining what state jurisdiction and what is federal jurisdiction. Okay. They say the functions of court is enforcement of normal values, standards, and expectations, especially behavior. They play a central role in enforcing society's rules, dispute processing, lawsuits requesting intervention of the government on their behalf, such as contracts, money, poverty, personal injury. I would go with this for the state level, because you have to have some kind of being able to negate anarchy. And when you have rules, you have to have people that interpret those rules and such. But see, the thing that bothers me is that word enforcement. Enforcement is not one of the constitutional designated jobs that they're supposed to do. They do play a central role in shaping society rules, which can be a problem. I have no problem with them intervening in disputes. Contracts, money, property, personal injury, all these have always been in the courts and have been settled there. The problem that I have is the words enforcement, because courts have always been designated as being the interpreter of the law. Functions of the court, reform. Every time that they make especially SCOTUS, whenever they make a major decision, it's going to have not a trickle down effect. It's going to have like a tidal wave. Think of Miranda. Miranda was in the 60s, and it's still hitting us. And, you know, I was given a card, and you carry that card, and you read it word for word. Now, if you've been on the job 20 years, you pretty well know it word for word, but many of them take that card, so they make sure they don't miss anything. Because what happens is, if you mess up with giving them their rights, then they can start screaming that you know, their rights were mistreated, and then you've got a basis for throwing out the case. Policy making. Again, show me in the Constitution where it says that the courts are supposed to make policy. Not going to find it. The courts were designated as the least powerful of the three branches. They were designated to interpret the Constitution. Defines rights. That's true. When a judgment for one law enforcement agency is handed down, then it's going to apply for all law enforcement agencies. This applies in situations like searches, questioning, management of prisons. Again, Miranda. Miranda went through all the levels. You know, the Fed guys have to give them Miranda rights, just like the local boys. This has increased the power of the courts. And the forefathers never intended for the courts to have the kind of power they have now. Federal and state court systems, they have trial and appellate courts. There are three levels of courts: the trial courts of limited jurisdiction, the trial courts of general jurisdiction, and appellate courts. All right, so you've all right, we'll say that you robbed a bank. Well, they're going to put you in a trial level court of general jurisdiction. Now, that trial level court will determine your guilt, and then the judge will lay down the punishment. Trial courts of limited jurisdiction handle only misdemeanors and lawsuits for small amounts of money. That would be like your small claims courts, your municipal courts, things like that. Your trial courts of jurisdiction oversee felony cases and all other civil lawsuits. Then, if there has been some kind of breach in protocol in the trial, where the defendant or the attorney believes that their rights have been violated and the judge did not correct that, then they have a right to take it to an appellate court. Like it says there, if the defendant believes errors have occurred by police or trial court which contributed to the conviction, it can go to the appellate court. The appellate court does not have juries. It has a bench of judges. Lawyers do not present evidence in appellate courts. They present arguments for or against whether this error contributed to the conviction of the defendant. If the appellate court rules against the defendant, then he has the right to take it to the state Supreme Court and then possibly SCOTUS. Now, the appellate court, they can have more than one question, but they can also just focus on one. Like, let's say the attorney wrote a brief and said, we think these 5 things were violated during the trial, and they look at it and they say, no, this is garbage, but yeah, you got a point on this one. And so they can bring that to the appellate court and argue that one point. Arguments are made about specific alleged errors of law or procedure that the judge failed to correct during the trial that resulted in determining the defendant's guilt. The appellate judges will then write opinions to explain why they ruled in a certain way. And they can get very verbose. All states have what's called a court of last resort. These are usually called state Supreme Courts. All but a few states have an intermediate level appellate court called the Court of Appeals. In the federal system, the Supreme Court of the United States is the court of last resort. In the federal system, U.S. Circuit Courts of Appeal are the immediate appellate courts. The trial court of general jurisdiction, courts in which the jury trials occur and judges impose sentences. Federal system has no limited jurisdiction trial courts. It'll go directly to a district court. Okay. Any questions so far?
Whatever you said that for the appellate courts, lawyers cannot present evidence. How do they argue a case without presenting evidence?
Well, they're not arguing evidence, they're arguing procedure.
Okay.
All right? And so what they will do is they'll say, well, the judge did not allow me to bring this evidence in that he was prejudiced against. And so because of that, I was convicted because this could prove my innocence. Well, they're not arguing the evidence there. They're arguing whether the judge was right or wrong in disqualifying it.
They'd be able to bring like a transcripted evidence?
I believe so, yeah, I believe so. The thing that bothers me though, and I haven't quite figured this one out, is when there's evidence that has been found to clear somebody. And it's my understanding that you can't bring that to these appellate courts. And that's what I don't know how. I'm going to try and get a lawyer up here to talk to us. And I'd like to find out how a person gets cleared when there's obvious evidence now that has been found to clear them. Now, this is fits right in with that movie I want you all to see, And Justice for All, because here, The lawyer has the evidence to prove that guy absolutely innocent. Okay? Now, he missed the deadline, and the judge is saying, no, I'm not gonna hear it. And so, you know, and the judge could make an exception if he wanted to, but that judge is a real hard-nosed. And so, again, here we are, you have an innocent man in prison. And he knows it, the judge knows it, the lawyer knows it, but the judge is abiding by the letter of the law. And so it can't be an appeal because he is abiding by the letter of the law. But morally, it's atrocious. What else? Y'all know how you become a judge?
You gotta go to like, start off as like a lawyer and such, or
Do what?
start off like a lawyer and such and just work your way up, or?
They don't you get voted to become a judge?
Okay. There's several ways to become a judge. A federal judge, you have to be appointed. The president has to nominate you, and that's like for just, you know, the appellate courts and such as that. The president has to nominate you, and it has to be confirmed by the Senate. Now, we have elections right now where there are judges that are wanting to be a judge, and they're having to be elected. And so, there's two ways. We're going to study that in a few minutes, but I just kind of, probably next week. But I kind of wanted to know if y'all had any kind of idea of how we have judges come in.
I knew they were like elected like federally, but locally, I have no idea.
That's why, you know, I don't know about y'all, but I've been seeing all over my neighborhood, such and such for circuit judge. So and so for circuit judge. That's a judge. You know, and now the state Supreme Court, if I'm not mistaken, the governor will appoint on that, but I need to find it out because I'm not sure. About that. Anybody got any other questions or any thoughts? Are y'all gonna promise me to watch the movie on Friday? Because if you don't watch it this time, we're gonna have to meet next Friday, and I'll show it in class. Okay? Deal? All right. Well, I don't wanna get into really the judge thing because that's an entirely new topic, and I like to kind of keep the topics together. So, if there's no other questions, y'all have a fantastic weekend. Let me give you your little cleaning sheets. Y'all have a fantastic weekend. Enjoy yourselves. The midterm grades have been posted, and I was very pleased